Well, welcome everybody. So glad you can join us here on this Friday, although it's not the happiest subject I've ever been trained on. Before I get to the presentation, we always start these about 5 minutes early. That's mostly so folks who haven't joined us before for webinars can make sure that their audio is working, everything that they need to do. I know that sometimes we've heard that people there's a download or it takes a few minutes. So we just get started a little bit early to make sure that everything's working. I will tell you, and I'll repeat this over again, if you have a question during the session, there is a questions panel that's off to the side there to ask questions. And what I'll do is I will get off your questions, and as it comes to a good point to stop Davey and ask him questions, I will make sure that we ask him your questions. But that's also the same place you'll use if there's audio or visual problems. You know, we've been doing these for a couple of years now. I'm pretty good at troubleshooting, and hopefully if something's not working, we can tell you there. Before we get going, I will tell you a little bit about Legal Services. Legal Services is the free nonprofit law firm for low-income people in the state. We have 8 offices statewide. We cover every county in the state of Alabama. Altogether, we do about 11,000 cases a year, which is a lot, but there's about 1 million people who qualify for our services in Alabama. So there's always a great need. And if you are wondering how you may be able to help with that need, a great way to do it is always to volunteer with the volunteer lawyer programs. There are 5 volunteer lawyer programs around the state. One in Huntsville, Birmingham, Montgomery, and Mobile, and then another program that covers the rest of the state. If you are interested in volunteering at this time, you can contact, there's a link on the State Bar's website that you can sign up to volunteer. But as another way to volunteer, if you're interested, which is being run out of the Equal Access to Justice Commission, the Access to Justice Commission, we are now implementing Legal Answers. Legal Answers is a program through the American Bar Association where people can put legal questions in. They turn in their low-income people. They apply online. They turn the question in, and then you simply receive the question by email and answer it at your leisure. The great thing about that is, as opposed to traditional pro bono work, which does take a fair amount of time. People have serious problems. If you're not able to volunteer for pro bono that way, you can do you can do pro bono at your office. You can be in Birmingham helping someone in Connecticut County, Choctaw County, what have you. So that is a great way to resolve your problems. Hopefully everyone can hear us. At least one person saying they can't, which I'll get to in one moment. Again, since it's getting closer to time to start, I will say again, welcome to today's webinar. Very excited to have it. Very excited to have Davey. And Legal Services will be having webinars probably about once a week, at least for the next month or so, dealing with COVID-19 issues. To the attorneys in the audience, I know we have some non-attorneys, and that's always great to have. We have some social workers, we have some businesses. Thank you for joining us. For the attorneys in the room, virtual room, if you want CLE credit, as long as you signed in and you put your bar number in, there's nothing else for you to do. The system will track the fact that you attended. We'll know you attended. We'll turn in and get you credit. So I always get 10 questions afterwards, and that's why I introduced this now. To get CLE, if you're a lawyer and you signed up and put your bar number in, nothing else for you to do. Watch the session, turn it off when it's done. There's a questionnaire, fill it out or don't, doesn't matter, and you will get credit. Nothing for you to do. And again, I mentioned this earlier, and we were expecting about 200 folks. So at some point, it may behoove you, Davey, about 10 minutes in to tell people this. If they have any questions, there's a place to ask them off to the side. I will, when Davey pauses, I will make sure to get him those questions. But right now, because of the number of people attending, we just can't have everyone speaking at the same time. So with that being said, it is 12 o'clock. I'm going to go ahead and turn it over to Davey, and I'll let Davey do his own introduction. But I will say, particularly happy to find out Davey is going to be doing this because in addition to all of his professional accolades and his great work, great reputation as a lawyer, Davey is also has a special place in my heart because Davey was my captain of my Ultimate Frisbee team for my first 3 years of playing Ultimate Frisbee. And so I can attest to the fact that in addition to being a great lawyer, Davey is also a great Ultimate Frisbee captain. And I recommend if he ever captains a team again that you all try your hardest to get in his team because it's a lot of fun. But okay, with that being said, I'm going to turn my camera off and turn it over to Davey. Again, if you have questions, ask them off to the side and I will pass them along to Davey and help you as best I can. Davey?
I appreciate that. I'm getting slower every year, so I don't know how many more captaining years I have, if any. But I always enjoy some extracurriculars. Okay. Obviously, we're here to talk about really the Families First Act primarily, but we're going to talk about some other laws that go into effect too. I will warn you, this presentation was rewritten as recently as 30 minutes ago because we keep getting updated guidance and updated laws. So we will talk about all of the laws as they exist at this very second, but things are going to change. So as I mentioned, we're starting here on our agenda with the Families First Act. This is what you might call the second wave of coronavirus response laws. It includes 2 paid leave acts that went into effect or will go into effect next Wednesday. They were passed last week. We are really not here to talk about the CARES Act. The CARES Act is not yet law. The Senate passed it. The House at some point will debate it. We don't know what it's going to look like at this point, so I may get some questions about that. I'll try to answer them based upon what I know about the law, but it's very fluid. So once we get through Families First, I just have a few quick notes on a couple of existing laws, the ADA, workers' compensation laws, even some OSHA safety guidance. And I'll give you a couple of tidbits about that because we tend to forget that we have all kinds of existing laws. We don't always have to look at the new ones. But what you will get at the end of this is a pretty good feel for the obligations of employers and the rights of employees as we get through this crisis. Got to have a disclaimer, right? Please don't view this as legal advice. It's not very specific. Furthermore, as I mentioned, is changing on a regular basis. So this will give you a good head start through today, through the weekend. The Department of Labor has not even issued its new regulations on the new laws. So I could be wrong on something. They could decide that they want to go a different direction. I'm going to give you my best read based on what we have so far. Starting with the Families First Act, we'll just get right into it. The Families First Act is a huge piece of legislation. It's much like the Civil Rights Act of 1964 in that it has lots of different titles. There's only 2 titles of that law that we're going to talk about today, and they're located at Division E and Division C of that law. The law also provided for testing and some other things. We're just looking at the paid leave requirements. Starting with the Paid Sick Leave Act, that's a pretty big change. It marks the first time in American history when employees had the right to take paid sick leave. This is something that European countries, even third world countries, have provided to their employees for a long period of time, but it's brand new for us. And it's pretty limited. It's a pretty small start, and it has an expiration date. But until the end of the year, it's going to have an impact. The next thing we're going to talk about is the FMLA Expansion Act. If you've counseled businesses or if you are a business with more than 50 employees, you're probably at least somewhat familiar with the FMLA. This is a new, leaner, meaner version of it. It does not provide unpaid leave, which is what the FMLA always provided. It provides paid leave. Also, it now applies to employers with fewer than 50 employees. So if you've got one employee, you are potentially covered under this expanded FMLA law through the end of this year. On the other hand, if you have more than 500 employees, you are no longer covered under this aspect of the FMLA. You remain covered under the existing FMLA that's been on the books since the 90s, but this new provision, which provides paid leave, will not apply to the nation's largest employers, which is about 50% of the country in terms of where people work. Those businesses hopefully are going to do some nice things for their employees, but they're not required to under either of these laws. Both of these laws apply to state and local governments. So if you work for or if you provide counsel for municipalities, counties, local boards, those entities are covered by this law no matter how many employees they have. So a tiny little town like Winfield, Alabama is going to be covered to the same extent that Birmingham or Huntsville will be covered. Starting again with the Paid Sick Leave Act, here's the general concept. It's going to pay some measure of paid leave to employees across the country. The employer is going to pay that money. The employer is later going to be reimbursed somewhat slowly for the amount of money that it has to pay. It is accurate to say that the employers are acting as loan agents for the United States government, because these dollars are ultimately going to be tax dollars. The economic effect on employers in the very short term could be pretty substantial. Obviously, the economic effect on employees will be very helpful to them during this time period. I will say the economic effect is going to be significantly lessened by some new IRS guidance that's going to let employers get their tax credits quicker. So if you're afraid you're literally going to go under in the 2 weeks that you're paying this leave, you may want to take heart, because the IRS is trying to get you the money quicker, and they may be able to do it. Here's an important aspect of the emergency paid sick leave law. There is no length of service requirement for employees. It doesn't matter how long they've been with you. They may have been hired yesterday. Come April 1st, they're going to be entitled to take some emergency paid sick leave if they qualify. And we will talk about how they qualify. So it doesn't matter how long they've been with you. We're going to contrast that with the new FMLA, which does have a little bit of a service requirement. As I mentioned at the outset of this webinar, there may be a few changes to these laws that are made by the CARES Act that's being debated. It was introduced by Senator McConnell a week and a day ago. It does have a few little impacts on these laws. They're pretty minor at this point. Something could change. Okay, so the emergency paid sick leave. Let's talk first about how you qualify, and then we'll talk about what you get. There's 6 different ways that you might qualify if you're an employee under the Emergency Paid Sick Leave Act. The first 3 I consider employees who are quote unquote directly affected by the coronavirus. And when I say directly affected, what I really mean is they think they might have it, they're experiencing some symptoms of it, and they're seeking medical treatment, or they have been advised in some way to stay at home, and it's not just social distancing guidance, it's some sort of recommendation or order from a person of authority. So that would be like your doctor tells you you need to self-quarantine because you may have it. Or there's a federal, state, or some sort of local order that says you're not allowed to leave your house, whether it's you or whether it's the whole community or your whole neighborhood. So those 3 categories of situations are people who I refer to as being directly affected by the coronavirus. Those people are going to qualify for emergency paid sick leave. Now let's talk about what those 3 categories of people would get. They're going to get their regular pay for 2 weeks, 10 days, 80 hours, however you want to call it. It is 2 paid weeks, 10 working days of sick leave. That is paid at the normal rate that you would normally pay to somebody, except that there are some caps. The caps are pretty high. Most minimum wage and hourly workers are going to be able to receive their full pay. Some people and some salaried workers may hit a ceiling. There are daily caps and there's a 2-week cap, an aggregate. So the daily cap is $511 a day. The aggregate cap over 2 weeks is $5,110. These are both gross amounts. These are not net amounts. So again, just to review, the people who get that much money would be those who are directly affected. They have a quarantine order. They've been told to self-quarantine by a doctor, or they are themselves experiencing some sort of symptoms. I do have a question that has not yet been answered by the Department of Labor. It says in the statute that they get the leave if they are experiencing symptoms and seeking a medical diagnosis. Well, what happens when they get their diagnosis and it's not COVID-19? We don't know. If it takes only a couple of days to get a test, do they get to go ahead and sit out for the rest of the 2 weeks? No clue. It doesn't say. My guess would be that once they definitively determined that they did not have the virus, they would end their leave entitlement at that point in time. Okay, let's go back to our 6 qualifying reasons for leave.
I will say, Davey, by the way, you have 3 questions about that. I don't know if this, if you're going to go into it further and come back, but people have a lot of questions about that.
Sure, go ahead.
If an employee has paid leave, as most government employees do, must the leave be used first and exhausted before the emergency leave is available?
So I will answer this question and probably your other ones as we go on. The answer to that is no. The employees have the right to immediately take this leave. They cannot be forced to use accrued leave first.
I'm gonna hold the rest of the questions.
I bet you I'll answer some more as we go, but we can do it either way.
I'll hold them to the end. Okay.
All right. So we got 3 more qualifying reasons for the leave. These are the reasons that I would consider indirect, right? These are people who maybe they're not directly exposed to the coronavirus. They're not directly subject to some sort of quarantine order, but it is still affecting their daily lives. The 2 easiest ones are 4 and 5. You're caring for someone else who can't be where they would normally be because of the coronavirus. So this would be children, right? So if your school is closed, or if your daycare is closed, or if your mother normally takes care of your children and she can't come over because she's been affected in some way by a precaution, you're going to have the ability to take 2 weeks of partially paid leave. The 6th reason is somewhat, unclear. Basically, the Secretary of the Health and Human Services has the right to make additional conditions known through regulations. We don't have the regulations. I don't know what they will say. Don't forget about this possibility. Go back and check the regs. They'll be out by Wednesday. But for now, excuse me, but for now, we don't know. Number 4 is a little bit unclear as well. Caring for an individual who is subject to a quarantine order. Well, who's an individual? And who decides whether you're the one that gets to care for them? We don't know the answer to that. I think quite logically, if it's a close family member, such as your husband or your wife, that's going to be an individual who I'm sure will be covered. If that person is subject to some sort of quarantine order and you're needed to be with them, I'm certain that applies. What if you volunteer to help a friend? Not so sure. Maybe that gets to the end of the spectrum. But we know for certain that if you have a son or daughter whose school is closed, you're going to potentially be entitled to some of this. So let's talk about what you would be entitled to in that event. You would be entitled to a smaller amount of compensation. Your normal regular paycheck is what you get, but there's caps. The caps would be no more than $200 a day, no more than $2,000 in the aggregate over 2 weeks. These are gross numbers. Again, we talked about the categories of people to whom this applies. Briefly, who is a son or a daughter in our brave new world? We incorporated terms from the Family Medical Leave Act. If you're familiar with that already, this will be a review to you, but it's a little bit broader than just your biological child. It also includes those who we have adopted, children who are foster children. It actually includes a stepchild. It includes a legal ward, and includes a child of someone who is standing in loco parentis, who is under 18. So what that might mean is someone who was raised by a grandparent or something like that, even though they maybe never had legal custody. Importantly, the age of majority for federal law is 18, not 19. Does not matter that we're in the state of Alabama. The age is 19. If you've got an 18-year-old high schooler who is out of school, you are out of luck. You are not entitled to any benefits under this law. However, if your 18-year-old or your 36-year-old is incapable of self-care, of course, you would be able to take the leave. All right, there are some huge exceptions to this law. We need to make sure everybody's very clear on the obvious exceptions. Teleworking employees is perhaps the biggest. If your employer offers telework, and we can talk about what it means, we don't really know what it means, then you're probably not going to be eligible for the most part. Couple of scenarios there. What happens if the person who is teleworking themselves contracts COVID-19 and they are, as a result of that, unable to telework? Common sense would tell you that that person would get their 2 weeks of paid leave. I cannot report to you that the statute says that. It's unclear. I believe that they would be entitled to that. But otherwise, if they're able to conduct telework, they would be entitled, would not be entitled to the leave. What is telework? Could someone argue that the employer merely provided them access to email and that's not truly telework? Perhaps. But keep in mind that if someone is teleworking, you are paying them. They are being paid by the employer their normal wages. It's going to be difficult for someone to argue that they are not being treated appropriately if their workload is reduced and yet they're still getting paid their full wages. So if a situation can be put together where the employee is teleworking and you're happy with it and you're paying them, most likely you escape some of the requirements of this law. One exception, and this was added by the Department of Labor to its guidance this morning. It says that if an employee who is at home taking care of their child cannot telework because their child is too young, requiring too much effort, and they're unable to complete the tasks that are assigned to them through telework, the employee would still be entitled to take the leave. Okay, so we actually have somewhat of subjective analysis. For employers, that's difficult. They have to decide what to do here. But the employee, if they come to you and they say, I can't get it done, I've got too much to do with my child right now, the short answer is give them the 2 weeks of paid leave. They're probably going to be entitled to that. Couple of other exceptions, healthcare providers and emergency responders. This will only really apply to public entities or quasi-public entities. Obviously, the statute needs the healthcare system to continue to operate, and so it gives the discretion to the employer as to whether to exempt emergency responders, including healthcare providers. We don't know what an emergency responder is. We certainly understand it's a police officer, it's a firefighter, it's a paramedic. We don't know what a 911 operator is or a dispatcher, who's someone who operates at front desks. We're going to need some definitions of that, but emergency responders may be excluded. It's going to be up to the employer. We do know what a healthcare provider is. A healthcare provider may also be exempted by the employer at the employer's option. They don't have to be. It's an employee-by-employee decision, but the employer can make that call. The healthcare provider, it means obviously a doctor, whether it's a DO or an MD, and it's also anybody else who the Department of Labor says. We know this list of professionals constitutes healthcare providers. It's pretty broad. Nurse practitioners, midwives, clinical social workers, PAs. It's a pretty lengthy list. The one thing that I draw the line at, I'm not sure that an LPN would be a healthcare provider. I believe that a nurse probably is. Okay.
Are dentists considered healthcare providers?
They are. They are specifically listed in the regulations. So a dentist, and most dentists are self-employed, but if a dentist works for someone else, and wishes and the employer wishes to exclude the dentist, that can be done. Okay, so a little bit more about ineligible employees. There are a couple of safety valves that are built into the Paid Sick Leave Act. These safety valves are also built into the FMLA law that we're going to talk about momentarily. The Department of Labor was given authority by Congress to exempt certain businesses from any of these requirements. The Secretary has to do that by regulation. Again, we don't have regulations yet, but apparently the Secretary has the authority to exclude healthcare providers and emergency responders separate and apart from what the employer might decide. The Secretary might decide that all of them are exempted, whether or not the employer wants them to be. We'll find out by Wednesday. The more important thing that the Secretary of Labor has the right to do is to exempt small businesses. All right, small businesses are defined as those having less than 50 employees. So if you hit 50, you're not a small business. If you have 49, then you might be. Now, there's a complicated method of potentially counting employees, and we don't know the answer to how it's going to be done. But the Secretary's regulations might provide relief for smaller businesses. Here's what the requirement will be. There will have to be some evidence that the paid sick requirements or the paid FMLA would jeopardize the viability of the business as a going concern, and otherwise it would risk shutting them down. I have some thoughts about how broad that will be. I think it will be pretty narrow. I suspect because of the IRS relief that is being provided to give quick payroll relief once this money is paid out, that a lot of businesses under 50 may still be covered. That is a hunch. That is an educated guess. But I've heard a lot of businesses say, "Oh, I'm just going to fire everybody until I get to 49 and expect relief." It's going to be a higher required show engine than just your number. The DOL has actually stated on its website that if you wish to claim this exemption, you might want to start documenting why you think your business will fail. Someone is going to look over your shoulder at some point. It's probably going to be the Department of Labor. It's possible it could be the IRS. The government, of course, is always very helpful. One thing it does say is, please don't ask us. We're not going to tell you. Please don't send us any materials. We're not dealing with it. So this is going to be something where you make a judgment call and you're going to find out later if you were right. So you have to get comfortable with that risk, because this is probably going to be coming up if some employee makes a complaint against you or a lawsuit is filed. You're probably not going to get advice in advance. However, once we get the regulations, your lawyer should be able to give you some good advice, and lawyers, you should be able to access the regs. Okay, so let's say that this regulation comes out and it says that businesses with fewer than 50 are exempted or partially exempted. How do we know whether you have 50? Most federal employment laws have a good way of determining that. It's usually your size over a time period. For instance, the FMLA, as it is originally written, says you don't have 50 employees unless you got that many employees on your payroll for 20 or more calendar weeks in the current year or in the preceding year. Okay, so the Title VII law is similar. The Americans with Disabilities Act is similar. We look at an employee count over time. So if you just drop your employees off tomorrow thinking you're going to miss the 50, it might not work. However, there is some possibility that this is not how it's going to work. We have a little bit of guidance from the Department of Labor, not on counting to 50, but on counting to 500. For purposes of knowing whether you are under 500 and therefore covered by these laws, the DOL has said that you look to the number of employees that you have at the moment the leave is taken. So just pause on that for a second. It took off the time continuum. It just said, if you have 500 employees on April 30th, when someone asks for leave, you're covered. If you have 499 employees, or excuse me, you have 501 employees on April 30th, you're not covered. It is possible that that freeze frame approach to 50 will also be adopted. If that's the case, some businesses might want to lay off staff now to get under 50. That might happen. There is no guarantee this will work. You're going to get guidance before April 1st, so I would say hold off just a little bit. Okay, now let's talk about a little bit more on the general rule. In general, you're getting 2 weeks, 80 hours, 10 days of paid sick leave, provided the triggers are met. The regular rate for what you're paid at is computed under the Fair Labor Standards Act. Typically, that's an hourly rate, but of course, if you have salaried employees, you convert them to an hourly rate just by dividing by 40 hours. There is a special rule for calculating the pay for part-time workers. I will briefly go through it. It's in the law. It's actually a little bit complicated. Again, let's talk about the cap for those taking care of a family member. $200 a day, $2,000 in the aggregate. There is a second cap that applies. If you are taking leave to take care of a family member under the Emergency Paid Sick Leave Act, you are not going to get your full pay. You're going to get 2/3 of your regular pay. First, you compute 2/3 of their pay, and then you apply the maximum caps, not the other way around. So if you have an hourly employee who makes $10 an hour, they're going to make $667 as their 2/3. Then you apply their hours to determine whether they hit the max for the day. We'll go through that. Just assume, I'm not a math guy, okay? So Michael, catch me if I screw it up. Assume you've got an employee who makes $20 an hour. They normally work 40 hours a week. Normally, they would get $1,600 if they were actually at work over this time period. That's just 80 times 20 because it's a 2-week pay period. Suppose they get a qualifying reason. You pay them their paid sick leave at their normal regular rate. That's $20 an hour. That employee would then be paid $1,600, the same as they would normally be paid, because this is not to care for a family member. This is to care for themselves. So they're entitled to their full pay up to the caps. So $1,600 is what they would get over that 2-week period. But let's check the caps. Is their daily pay more than $511? No. 8 times 20 is just $160 a day. All right. Is their aggregate compensation greater than $5110? No. Their total compensation for the 2 weeks is just $1,600. The caps never come into effect, and there you go. Let's talk about part-time employees briefly. You're supposed to take their hours of paid sick leave and determine that by reference to the number of hours that they would normally work on average over a 2-week period. So a part-time employee gets what they would normally get in a 2-week period. So let's just assume their regular rate of pay is $10 an hour. Let's assume they work 20 hours a week, not 40. So that's 40 hours total for 2 weeks. Their normal 2-week pay, if they're under quarantine, would be $400, and that's what they're going to get paid. So let's take that same employee and let's assume that they need leave to take care of a child. They're subject to an additional set of caps. If it's to care for a child, it limits their pay to 2/3 of their regular pay. This is important. You first compute the regular pay by reducing their hourly rate. It's $10 an hour times 2/3. It works out to $667 an hour. You might notice that that is less than the minimum wage. The statute to me is confusing about whether you're permitted to pay less than the minimum wage, but the Department of Labor clarified this morning. It says that an employee taking leave is entitled to their 2/3 of their regular rate or 2/3 of the applicable minimum wage, whichever is higher. So in this case, 2/3 of $10 would be higher than 2/3 of the minimum wage. This also assures us that you can pay sub-minimum wages, even if the 2/3 requires it, okay? So with this example, we've got a $10 an hour worker who's only gonna make 2/3 of that, $6.67 an hour. Then you need to calculate their hours. 40 hours, that's a 2-week period for this worker, times 667 is only $266. Now you'll note that the hours are not reduced to 2/3. We're only reducing the wage rate. The hours are going to be their normal hours. Now you're going to check it against the other caps. Is their rate of pay more than 200 a day? It's not. Correct. It is 8 hours times 67, so it's only $53 that day. How about the 2-week cap? Is it more than 2,000? No, it's not. It's less, so that's how much money they get. Now, I'll give you a caveat. If a part-time employee's time wildly fluctuates, they're just on call, there's a whole set of regulations for how we do that. What if an employee typically works overtime? Okay, a lot of people have asked me this question. There is no overtime premium for this work. Okay, there is no overtime premium. The regular rate does not include the premium rate for working more than 48 hours in a work week. Okay, so you do not pay them time and a half, even if they work overtime. However, the number of hours they normally work remains the same. So then if they normally work 65 hours a week, that first week they would get 65 hours. And it would be reduced to the second week because you have an aggregate cap. Yeah. So salaried employees.
Are you gonna, someone had asked about a service employee making the service wage, the $2.13 an hour. Are they gonna automatically get minimum wage?
They're gonna automatically get minimum wage because it's gonna be higher than their regular rate. So you're not gonna get the tip credit. You're going to compute that regular rate and it's gonna be minimum wage. And I think that is the purpose of the exception that we saw in the statute. I will say we've not seen guidance on it yet, but that's the way I interpret it. Salaried workers is pretty easy. Divide their salary by 40, you come up with a number. Okay, now this is going to be the part of the presentation I get to some of the questions you asked earlier. The first one is, well, how do deductions work for health insurance, 401k plans? Presumably, the paid leave can be reduced by these items. In other words, you could withhold on some of this. In general, the wage and hour laws would permit you to have pay below a minimum wage because someone has elected health insurance or something similar. I see every reason to believe that that is the same under this law. We don't have any regulations on it yet. So, check back on this for sure, but we believe that you can deduct your normal deductions. As I mentioned, the pay will not include any premium for overtime hours, but it will include, you will, under the Emergency Sick Pay Act, compute the number of hours by reference to their normal working arrangement. So another question I get quite often is, well, how do I know if an employee is going to do this? How am I to plan? The preliminary guidance from the Department of Labor says that where the leave is foreseeable, and if somebody's school is closed, I would say it's quite foreseeable, the employee is to request, the employer can request that the employee provide such notice as is practicable. So in other words, you could put out a memo to your staff saying, hey, we need to know if you plan to use this to the extent that you can predict it. Now, if they can't predict it because they contract the illness or they get subject to an order, that's not going to matter. But if they can predict it, they do have an obligation to tell you. What if they don't? The FMLA would say you could deny the leave. We don't have guidance under the Emergency Paid Sick Leave Act. let's talk also about the question that was posed earlier, the interaction with accrued paid leave. Congress said that the employee's right to paid sick leave is immediate. In other words, they do not have to be subject to any sort of waiting period. They get it April 1st. They can take it April 1st. They can decide to take it later, as late as December, as long as it gets taken, if at all, by the end of the year. Okay, so if they take it, can you make them burn through their accrued leave? The answer is no, you cannot. The employer may not force them to exhaust their accrued leave first. You do have 3.5 days until this law goes into effect, or 2.5 days. You could make them use it now if you wanted to, because the law doesn't take effect. But you cannot force them to use it before the emergency sick leave when the statute comes into effect. Now, if an employee takes FMLA leave, which we'll talk about in a minute, the paid FMLA leave, the first 10 days of that paid FMLA leave is actually unpaid. But you will notice that these two laws fit together like a puzzle. The Emergency Paid Sick Leave Act allows for 10 days of paid leave. The FMLA provides for unpaid leave for the first 10 days. You can put them together. The employee can choose that for that first 10 days of emergency FMLA, they want to receive the 10 days of emergency pay. They can do that. They might decide they want to use accrued leave instead of doing that, and they could also do that. And we'll talk about that more in a minute. People have asked me, can we have the employee spend some time getting coverage for their shift if they are going to take this leave? The answer is no. The law specifically provides that employees shall not be required to search for or find a replacement employee during the hours that they're covered. So unfortunately, it becomes an obligation for you. And what you could do is, for your existing workforce, have them develop some backup plans now before they ever elect the leave. But once they elect it, you cannot require them to search for a replacement. So this is a management task you'll want to do yourself right now. Other people have asked me a great question. I had no answer to it until this morning. What if an employee says, all right, I have 80 hours of paid leave available. I want to spend 10 hours a week taking care of my kid. My wife can do the balance of the time. And that way I'll spread my emergency sick leave out over the course of the whole summer or something like it. Can they do that? What we would call that is intermittent leave. And the Department of Labor has said that they can only do that if you choose to let them as the employer. It is up to the employer. So that is pretty important. It's a little different than how it normally works under the FMLA. So, and that is true under both the FMLA leave I will be telling you about and under the emergency sick paid leave. So if the employee approaches you and says, hey, can I split it up? And you want them to do that, great. That's a good arrangement. You can agree to it. Keep this in mind. You must be careful not to discriminate against employees in terms of who you allow intermittent leave and who you do not allow it to. An employee could claim that they are denied the right to use intermittent leave on the basis of their race or disability or sex or some other protected status. So it is best to make a decision on a department by department basis, or the entire business make a decision on how you're going to handle any intermittent leave. But importantly, you have no obligation to require it. It is completely up to the employer. Another thing that came up, the Department of Labor says, unless the employee's teleworking, if they do elect to take the paid sick leave, the 2 weeks, 10 days, 80 hours of paid sick leave, they're traditionally and typically supposed to take it in a full block. Now, if the qualifying reason ends, if their quarantine is lifted, if they are told that they don't have coronavirus, then the qualifying reason for the leave would end and you would need to bring them back to work. This is important. it's not just a matter of being friendly to employees. You might decide, hey, you know what? I see that the quarantine ended, but let them finish out their 2 weeks, and we'll get paid by the government for this anyway. Be careful. It could be federal tax fraud. The IRS is going to require that you have documentation in your file to support the payroll tax credits. So there is no being friendly to employees. You're going to have to be able to support and prove if you get audited. Remember, you're claiming tax credits. So you can only allow them to use this leave if they actually qualify. I know that that is unfortunate and that people are not going to be happy about that, but it's pretty important to remember. Here's another question we get a lot. What if you don't use it this year? What if they keep meaning to use the leave, but you never get around to it? You can't take it with you. The Department of Labor guidance says that you are not entitled to carry it over to next year. This entire plan, this entire benefit is over December 31. What if the employee quits or is fired or retires? It is not compensable at the time of separation. So you're not going to get it if you leave employment. You're not going to get it if you don't use it this year. It is not a compensable benefit in any way beyond actually using it as described in the law.
Davey, I will take a minute to tell you that if you're trying to pace yourself, you have about 15 or 16 questions in the hopper. So whenever we may not get to them all, and I apologize to everyone on, but we have a lot of questions once you're done.
Okay, that's fair enough. And I've got some ability to stop a little bit early, so I don't mind doing that. I'll follow your advice, Michael. You tell me what to do.
Well, I think like a lot of times when I'm doing these, I kind of pace myself. No need to pace yourself. I think once you open for questions, you'll get even more. So just move as briskly as you can.
Okay, fair enough. All right, I talk fast, so this should not be a problem for me. I mentioned the documentation requirement. People have asked me, can I require some sort of documentation? The answer is yes, and not only yes, but you should require some documentation. This morning, DOL said that the employee is required to provide documentation in support of the paid leave. It could be as simple as an email from the school saying the school is closed. You'll still want to get a copy of that. Otherwise, it needs to be a doctor's note saying they need to stay at home, or it could be a quarantine order. Now, obviously, you can download it on the website if you know that your city's under quarantine, but keep a copy of it. You're going to need that. You're supposed to maintain the documentation just like it's a tax document. You may need it when you claim your tax credit, as I mentioned a minute ago. I think I've already answered this question. The leave is immediately available. There's nothing in the law that lets the employer decide when you're going to take the leave. If they say, I want to take it April 2nd, they get to take it April 2nd. There is no credit given for you may have employees who are already taking paid leave right now. You don't get a credit for it. You don't get to say, I already gave them their 2 weeks. Unfortunately, this is a new benefit. Similarly, what if you say, well, I already give employees 5 weeks a year. They have plenty of accrued leave. It doesn't matter. Now they have 7 weeks. Now, so how does that fit in with the fact that you're supposed to get documentation? I have a suggestion. This documentation should be easy. I wouldn't delay leave more than a couple of hours. Ask them to give it to you. If they don't give it to you immediately, tell them, stay home. You're subject to the leave, but you got to get me that documentation. If they can't meet the deadline, just follow it up in a letter or an email and get it on the back end. I've got some form letters. Somebody wants to contact me, we can talk about those. Of course, if somebody lies and claims leave they're not entitled to, sure, they're potentially entitled to discipline, but be careful. This law has some teeth. It would be a violation of the Fair Labor Standards Act, double damages, attorney's fees, no retaliation requirement, and anti-discrimination requirement, so be careful. Okay, a few other things. Trying to move as quickly as I can. Furloughs and layoffs. If you're in, everybody wants to know the question, this answer, so let me give it to you. If an employee is furloughed, they are not entitled to the leave. If an employee is furloughed, they do not get the leave. Similarly, if an employee is laid off, they do not get the leave. It doesn't matter if the layoff is today or if the layoff is after April 1st. If they are furloughed, the DOL takes the position that they don't need the leave because there's no hours available to them. Similarly, if the work site is closed, they aren't entitled to the leave. If they can't work at home, they're just out of luck, unfortunately. They can claim unemployment, and that would be perfectly acceptable. And in fact, if you will help them file unemployment, your experience rating will not be affected during this crisis. Continuation of benefits. The employee does still have the obligation to pay for the health insurance. Department of Labor is clear about that. You can continue to recover it from them on the back end. I would not cancel coverage if you could avoid it. There are some things you can run into. So if you can during this time period, the DOL instructs you that you should and you must, in fact, continue group health insurance coverage. Okay. This will be a shorter segment than the other one, so we can kind of breeze through. This is the Emergency FMLA Expansion Act. Many of the things I told you about the Emergency Paid Sick Leave Act are the same here. The FMLA is more limited than the Paid Sick Leave Act. However, the potential length and dollar amount of the leave could be more. Here's what it does. It expands the FMLA on a temporary basis through the end of the year. It now applies to all employers under 500. There is one requirement. The employee has to work for you for 30 days first. Okay, they have to work for you for 30 days. That's all. And we can talk about that in a minute. You may be eligible for leave under both the FMLA and the Emergency Paid Sick Leave Act. The FMLA only allows for a total of 12 weeks of leave, okay? So you get 2 of those weeks potentially through the Paid Sick Leave Act. Well, you got 10 left under the FMLA, okay? So up to 12 weeks of leave. Let's talk about how you get it. The FMLA already allows unpaid leave in certain circumstances. New child, serious health condition, things like that. There's one new category and only one. That is a qualifying need related to a public health emergency. That qualifying need is very limited. That qualifying need is only the need to take care of a child under the age of 18. Okay? So the only way your employee gets paid FMLA leave is because they need to care for a child, because the child's school is closed, their daycare is closed, their normal child care provider is unavailable, and they are unable to work or telework as a result of that, okay? So in all cases, the closure that necessitates this leave has to be related to COVID-19, okay? So if a school closes just because it wants to, that wouldn't qualify. I don't think that would happen. Everyone who's closed right now is closed because of the virus. So if they are closed, that is the only way the employee gets leave, okay? Again, they have to be unable to work or telework. Whether they are unable to telework is subjective. If they tell you, I can't telework, my child is 6 years old, I have to be watching them, then that's true. They're potentially going to get the leave for that, and I'm not sure you can really question it. So again, the FMLA really only applies to parents. A mandatory quarantine, a public closure order, experiencing symptoms of the virus, none of those things get you paid FMLA leave. That may be hard to swallow. None of those things. Keep in mind, if you were already covered by the FMLA, then you continue to be covered. So you might have unpaid leave available to people who have a serious health condition. Let's say they get COVID-19 and they're in the hospital. They're going to get unpaid leave under the FMLA if they're covered, but they don't get the paid leave. You only get the paid leave if you're a parent with a small child. Okay, applicability. It applies to all government employers. It doesn't matter how many employees. Every small town, every large city, Every county is covered by the FMLA law. All private employers with fewer than 500. So if you hit 500, you're not covered. If you're 499, you are covered. There's some confusion about some of the 75-mile work sites rules that apply to the FMLA. We don't have an answer yet to it. For the most part, if you're under 500 employees, I consider you covered by the paid FMLA. All right. Normally, the FMLA says you don't get FMLA unless you worked there for 12 months. That is suspended for this law. Paid FMLA leave, you only have to have worked there for 30 days. Similarly, the hour of service requirement, normally under the FMLA, you only get it with 1,250 hours of service within the last 12 months. That is suspended. It doesn't matter how long or how many hours you've put in there. Okay? We may get a carve out for small businesses. I already talked about that carve out. It would be people fewer than 50. It would only be if it jeopardizes the viability of the business. We don't know yet what that means. Perhaps we will by the time I get off this call. There is one rule that's written into the statute. Let's say you have less than 25 employees. You might not have an obligation to reinstate. If you grant them the FMLA and you only have 20 employees, while they're out, you eliminate their job because you don't need that position anymore. You can't afford it anymore. You don't have to reinstate them, but you got to follow up with them for a year. If you create that position again within a year, you would have to reach out to them and ask them if they want to come back. And if they say yes, you have to hire them. If they say no, you're good. Again, as I mentioned, the first 10 days are paid, or excuse me, are unpaid. First 10 days are unpaid. However, the employees can choose to substitute their accrued leave in this time period. It's up to the employee. You cannot force them, but they can do that. I don't think anybody will. In fact, I think they will use their 10-day window for their emergency paid sick leave. Again, they fit together like a puzzle piece. So they could probably have 10 days of that emergency paid sick leave for any of the qualifying reason. The balance of the 10 weeks would be paid FMLA. Okay? Again, we default to the maximum of 12 weeks. We're talking about a total 12 weeks if you hit every qualifying reason. What if the employee has already exhausted their 12-week FMLA entitlement because they had surgery or they had a new baby? Unclear. The law doesn't say. Personally, I believe they're out of luck. No new paid FMLA if they've already used their unpaid FMLA. It's a total of 12 weeks, in my opinion. While you're out on the paid leave, it is capped at 2/3 of their regular rate. We already talked about how these caps work for the Sick Pay Act. It's the same thing. It's 2/3. And then there's some aggregate maximum of 10,000. If you get paid sick leave and FMLA, it's an aggregate total of 12,000. Reimbursement. Everybody wants to know, how do I get my money back? The Act states that the reimbursement will come in the form of a payroll tax credit in the next quarter. However, the IRS has put on its website that it is going to prepare for immediate reimbursement. When you file your payroll taxes on a monthly basis, you're going to tell the IRS who you have paid and how much. You're going to get to keep what you would normally withhold from all of your employees to make up for it. It's a dollar for dollar credit. You're going to get it immediately. This provision is going to be codified into the CARES Act if it passes. So you may have no payroll tax liability and you will effectively be reimbursed. If you're self-employed, you can claim the credit on yourself. There's more information on this link. Go to irs.gov. It's in the newsroom items. You'll be able to read about what they said. This is a little bit of information about how you do this. Basically, it's your employer's share of the payroll taxes. It's the employee's share of the payroll taxes. That's going to be 15% of what you're paying them. Also, the income taxes you're withholding another 20%. You're going to have to be 35%. You're going to get an immediate credit. Okay, so as you do this, you're going to find that you're recovering as you pay. Bad news for the government, no tax credits. This is an unfunded mandate for governments. They are not able to claim the credits and there is no reimbursement available. All right, so big takeaway, I'm going to open it up to questions. Most employees are going to get 80 hours of paid sick leave. Some parents are going to get more, up to 10 weeks. Law goes into effect next Wednesday. If you have never dealt with the FMLA, you need to get some legal advice. So let me open it up.
Okay, well, I'm gonna go as fast as I can and try to consolidate them if I can. Can you get emergency paid sick leave and unemployment at the same time? I know the answer. What is it?
No, you cannot.
Okay. That's because either the person's an employee or they're not an employee, that in which case they're unemployed.
Exactly, that's right. And if they've lost hours, but they're still getting the sick pay, so you can't get them both.
Yeah. Does this act cover loss of hours due to COVID-19 due to a loss of business? Not employees not taking care of, employees not sick or taking care of children, only lost business.
No. So it would have to still be a qualifying reason. It doesn't matter that you have nothing for them to do. If you have nothing for them to do, best thing for you to do is furlough them. They can claim unemployment. They're not going to get the benefits of this law.
And just to be clear, someone had asked, you've just answered it. This law, how does this law apply to someone who was furloughed or laid off recently because of the reason business conditions? This isn't going to apply to them, right?
Exactly, correct.
Somebody asked if people are uninsured and have no access to a healthcare provider, how do they qualify? So you had several questions about how employees should notify their employers they plan that they want to take the benefit.
Well, to inform your employer, it doesn't really matter how. You just send a text message, call them, send them an email. Make sure you tell them when you want to do it and for what reason. Make sure you have your documentation ready because they're going to have to ask for it. In terms of getting health insurance during this time period, if you're furloughed or laid off, you may have rights under COBRA. Your employer should give you a COBRA notice where you can elect. You can also go on the exchange and seek coverage under the Affordable Care Act.
All right. If an employee makes enough money that their salary would hit the cap, can they use a company like PTO or ETO or leave to up to their normal salary?
That's a great question. It's up to the employer. The DOL says there's no requirement that the employer allow this. I suspect only government entities will allow it.
Okay. I'm going to go ahead and I'm trying to delete. People kept asking what form they had to fill out, but there is no form.
Well, there's a form at some point in the future, but right now there is no form.
Let's see if employee, as a physician whose medical board has called for ceasing office and surgical treatment, I have to close my office. My employees are not working. We are not quarantined though. Are my employees entitled to this sick leave?
No, since you've had to close your office and they're on a furlough, they would not have a need for leave and therefore they're not entitled to the sick leave. They can file for unemployment. If you will waive your right to respond to unemployment, the experience rating that normally affects your taxes will not affect you, and they can get those wages right now. Now, if you start working again and they have hours to perform, they would potentially be entitled to the paid leave.
Going back to the 6 qualifying reasons, if a part-time employee already homeschools their kids, then does the automatic qualifier for taking care of children still apply?
So that's a great question. If they're already homeschooling their kids, I assume that the person who works is not the one homeschooling. So we would need to look at whether the normal homeschooling spouse is unavailable to do it. If that homeschooling spouse remains available, I don't think they would be entitled to the leave. But if that homeschooling spouse comes down with a condition or something, and the actual employee has to take over, then they may be entitled to it.
So if it's someone working thirds at Walmart, well, I guess it would be Walmart because this doesn't apply to people over 500. But some say that, and they always homeschooled.
I see.
Yeah.
You know, the answer is probably not. They probably would not be entitled to that. But that's a tentative answer because it's an unusual question. I have to think about it a little bit.
Do the rules applying to, God, there's just, the questions are getting bigger, not smaller, Davey. Does this apply, do the exactly the same rules apply to public employers as the other private employers in this law? Which I think the answer is yes.
They do, with a couple of exceptions. Certain federal government entities are excluded. And if you're an emergency responder or healthcare provider that works for the government, you might get excluded. But otherwise, yes.
Somebody just asked, where are you getting your information? The law was only recently passed. How are you figuring this stuff out?
Yeah, so, well, experience helps a little bit. I'm already familiar with most of the laws, and so I know how they fit together, but go to the Department of Labor website, dol.gov. They have a page on these laws, and they're updating it hourly.
Say a person is a restaurant worker who feels sick, they have no insurance, they cannot afford to go to the doctor. Are they entitled to sick leave? How do they prove they meet the qualifications?
If they believe that they have the symptoms of COVID-19, they are entitled to the 2 weeks of sick leave. They'll need to get a doctor's note when they go to the doctor.
And I will say, Davey, this is the first. We've been doing these about 3 years. It's still the questions are still coming in, folks. I don't know what to tell you. We have 200.
Welcome to my world for the last week. It's okay.
Well, you got 230 people. There is a copy of the presentation is attached, the handouts. Everybody who keeps asking for the handouts there. If you look in the bar, there.
Just y'all, please remember that things are being loaded daily, so don't rely on this in 2 weeks.
Same question by a dentist about closing down. Hopefully he listened to the one about the other doctor.
Yeah, if he's self-employed, he might be able to claim the credit.
And are pharmacists included as healthcare workers? Great
question. I think no, but we're waiting on some guidance to be sure about that.
Right. Well, I'm gonna have to cut it off today because it's just I don't know that we're gonna answer all these questions. I guess the answer is a lawyer.
Let me get you to the end of the slideshow real quick and give you some resources, okay? So here's my phone number. Here's my email address. You can look me up. I have a blog where I'm updating this, thirdshiftblog.com. My law firm, Linear Ford, has a task force of which I'm the leader. We have a lot of resources available on our website. We're attempting to keep them up to date. They may not be perfect, so call us. We'll be happy to have a consultation with you. If you're a lawyer and you need a quick bit of advice, I'll be happy to hand it to you. More than happy to answer any questions offline if you want to talk to me in any way.
Well, thank you very much, Davey. It's not usually this exciting, but I appreciate you are cool under pressure, as I knew you were from Frisbee. Thank you so much, and have a good day. Everyone else be safe, and be on the lookout, the rest of you, for I think we're going to be doing more housing and consumer related stuff next week. But everyone have a good day and stay safe. Luck.
Thank you.